In this video, I'm going to talk to you about the crime of misdemeanor assault in the state of Arizona. Hi, I'm Javier. I'm a criminal defense attorney in Tucson, Arizona, and I help people fight for the freedom and protect their future. Let's get on with the video. All right, so misdemeanor assault, what is it? Well, let's start by what is a misdemeanor? Traditionally, in common law, misdemeanor was just a label that was given to any crime that was neither a felony or treason. And nowadays, the distinction has kind of been preserved. So now, basically, a misdemeanor is a crime that is less serious than a felony. It can be punished, but like any other crime, by a fine or confinement, some forfeiture maybe. One key difference is a confinement can't be in prison. So usually, if you're confined, it's in county jail, right? Basically, what you need to understand is it's a lesser level of offense. It's not a high level of offense, right? It's not a felony. That's kind of the definition, right? And also the length of the potential sentence of confinement is also not as long as a felony. Right? So there's basically three levels of misdemeanor in the state of Arizona. You have a class 1 misdemeanor, class 2 misdemeanor, and class 3 misdemeanor. 1 is the highest, 3 is the lowest, right? So basically the differences are as follows. A class 1 misdemeanor has a maximum penalty of confinement of up to 6 months, $2,500 fine, and up to 3 years probation. An example of a class 1 misdemeanor is a standard DUI. Class 2 misdemeanor has a maximum confinement of 4 months in jail, maximum fine of $750, and a maximum probation term of 2 years. And then an example of this would be reckless driving, right? That's a class 2 misdemeanor. And then a class 3 misdemeanor has a maximum term of confinement in jail of 30 days with a maximum fine of $500 and a maximum term of probation of 1 year. An example of a class 3 misdemeanor would be the crime of adultery. It's still a crime. They can't prosecute it unless the offended spouse wants the prosecution, but it's still a crime, a class 3 misdemeanor. Interesting tidbit. That's what a misdemeanor is, right? So a misdemeanor is a crime that's less than a felony. You can't be sent to prison for it. And the maximum confinement you can get in jail is up to 6 months, right? The maximum fine would be $2,500. So now, what is assault, right? So traditionally, we had that assault and battery definition in common law, stuff like that. Doesn't exist anymore in the state of Arizona. Now we just have assault. This is ARS 13-1203. The statute describes 3 behaviors that are considered assault in subsection A, and they are numbered 1, 2, and 3. Okay. Interestingly enough, 1 is a class 1 misdemeanor, 2 is a class 2 misdemeanor, 3 is a class 3 misdemeanor. Okay. So anyway, let's start with that, right? Let's see what conduct, what behaviors are considered assault in the state of Arizona. So the first one is to intentionally, knowingly, or recklessly cause any physical injury to another person. Okay. So the big thing is physical injury it would be causing the weakening, damage, or diminishment of a state of being of a person's body. So again, it's kind of vague. It's really open. Like a lot of things can be it, right? So I mean, clearly, if somebody's got a bruise, some visible scratches, a little bleeding or whatever, clearly those are physical injuries, right? But sometimes when there's no mark, is it an injury? Is it not an injury? There's a case out there. Some people argue that pain can be an injury. Some people argue that it can't be an injury. I think the issue here is, again, if you cause somebody pain, let's say you pinched them. Well, was that an impairment of a physical condition, right? Did that weaken, damage, diminish a condition in that person's body, a state of being of that person's body? I'm sure a lot of people would say no. Clearly, if I'm your attorney, I'm going to say no, right? And we'll try and figure out a way to convince the judge that that's not a physical injury, right? I mean, there's clearly some physical injuries that would definitely count. I found one unreported case that kind of tries to explain this and kind of tries to get into this, the difference between, physical condition and non. And basically in that case, what the court said, and this is not reported, okay, so this is not binding on any court, but the court said that scratches or scrapes that go unnoticed by the victim and that are not accompanied by any pain and that do not result in the reductions of one's ability to use the body or a bodily organ for any period of time do not constitute the impairment of a physical condition, right? So if you didn't notice, it didn't stop you from, doing whatever, you didn't hurt, you just kind of say, oh, what happened, right? And that might not be a physical injury, but, it's going to depend on your judge and it's going to depend on your court. Now, there's a mental component to it. right? You have to intentionally, knowingly, or recklessly cause the injury. So one of the things that you need to understand is this is a crime of result. You must cause a specific result. So there's a causation and a result. So whatever it is that you did as a consequence that somebody suffered a physical injury. So, but you also need a mental state, right? You have to do it intentionally. You want to cause that injury, right? Knowingly, you engage in a conduct knowing that the conduct could or would cause that injury, right? Or recklessly, you engage in you didn't want to cause the injury, you didn't know the injury would cause, but you engaged in the behavior that assumed an unjustifiable risk that the injury would occur. So then it is an injury. So then that would also be assault. So the state would have to prove all these elements, right? That you behaved in a manner that had an intentional, knowing, or reckless mental state, and that behavior caused that physical injury. If they can't prove any of those, then you don't have a A1 assault, as we call it, because it's a subsection A1 of 13-1203, right, which is the assault statute in Arizona. Originally enough, we called that A1 assault. An A1 assault is actually a class 1 misdemeanor. Right? So now there's A2 assault, right? Another conduct that's also considered a misdemeanor, right? A2 assault, class 2 misdemeanor. What conduct is this? Well, intentionally placing another person in reasonable apprehension of imminent physical injury. So we know what physical injury is, right? But in this case, there is no actual physical injury caused. The result is not the actual physical injury. It is the placing of the other person in what's known as reasonable apprehension of imminent physical injury. So the best way to explain it is that whatever you did caused them to believe that they were going to be hurt. They were going to be injured physically, imminently, right away, right? So that's basically how it goes. So pointing a gun at somebody would put them in that situation, although using a gun would probably be a felony. But basically engaging in some kind of threatening behavior, right? Like, I'm going to punch you, and, punching and just stopping it right in front of their face. Scaring a person by your behavior, that you're going to get hurt right away. But it must be imminent. Right? So for example, if you're on a video call and you say, you take a gun and I'm going to shoot you right now. Well, clearly that's not imminent. There's no way that that's reasonable, right? So based on the facts, whatever you did must put somebody in a reasonable belief that you're going to hurt them right away, or that they're going to be hurt right away, immediately. And it has to be intentional. So whatever you did, you actually have to do it with purpose. You want to put them in that state. If you did something without the intent and the result happened, it's not enough, right? If you did it recklessly or knowingly, it has to be intentional. And that is a class 2 misdemeanor, right? And then you have the A3 assault, right? Knowingly touching another person with intent to injure, insult, or provoke such a person, right? So you don't cause an injury. You're not placing that person in fear that you're going to hurt them, but you touch them in a certain way with a certain intent. For example, you start pushing each other and stuff. Like, they're not hurting each other, right? But they're pushing each other, trying to provoke the other or stuff like that. That could potentially be one. Touching does not have to be actually with your actual hands or with your actual body. So throwing a substance at somebody could potentially be touching. So there was this case where somebody threw some human urine at another person. Clearly that was meant to insult them and or provoke them, right? That was considered to be sufficient, right? That is an actual touching that is clearly directed in insulting or provoking or offending another person, right? That's a class 3 misdemeanor, right? So that is, in a nutshell, what misdemeanor assault is. All of these are misdemeanors, class 1, class 2, class 3 misdemeanors. They don't require prison time. So how do you defend against a misdemeanor assault? It depends on the facts of your case. It depends on evidence that the state has against you. It's a very fact-intensive matter, but self-defense would be one defense, or, because it's justification, right? You can use force to defend yourself or defend others, right? You want to defend your home, right? So there's certain behaviors that justify you using some kind of touching another person, right? So certain situations where you're justified in touching another person. So it depends on the facts of your case. Another might be, for example, that the elements of the offense are not there. So let's say you're charged with an A1 assault, right? Intentionally, knowingly, or recklessly causing injury to another person. There's no evidence of injury, right? I mean, they say something happened and the person, yeah, but when the cops come, there's no injury, right? And they try to look, no injury, right? But the prosecutor's going to have a difficult time in proving that. I had a case, and actually there's a testimonial on my website from Michael. He was originally charged with assault, causing injury, A1 assault, but there was no injury. And the victim himself said, yeah, no, I'm fine. There's no injury. He didn't hurt me. Okay. So then how are you charging him with A1 assault? The best you can do is an offensive touching. Right? You can look at that video, put up the card up here. That's exactly what happened after some discussions, and after we set the case for trial, the state modified or amended the charge to an M3 from an M1, right? So that's one of the ways you defend it, right? And then let's say you're charged with the A2 assault, intentionally placing another in a reasonable apprehension of imminent physical injury, right? Well, in that case, it wasn't intentional, man. I mean, I was doing something else. Yeah, I scared the guy. I'm sorry, but I didn't have the intent to put him in that mental state, right? That's a clear defense. You're attacking the elements of the crime themselves, right? His fear or his belief was not reasonable under the circumstances. Again, attacking those elements of the offense, right? The injury was not imminent, right? So if you say, oh, tomorrow I'm going to shoot you, or tomorrow I'm going to take a bat to your head. Well, that might be a threat, but the injury is not imminent. It's not immediate. Right? But it still goes to the elements of the offense. Knowingly touching another person with an intent to injure, insult, or provoke. I didn't know I was touching you, right? I mean, I don't know, you're walking by in a crowded place and you touch somebody the wrong way, but sorry, I didn't know I was touching you, right? I bumped you or whatever. I'm sorry. I didn't know I was touching you. It wasn't my intent to provoke you or anything like that. So those are attacking the elements of the offense, right? Remember, the state has to prove every single element beyond reasonable doubt. If you can find at least one of those elements that can be proven, or you can actually disprove one of those elements, even better, right? There's also justification defenses, and there might be other issues, but those are fact intensive. You need to talk to your attorney. Sometimes victims are unbelievable, particularly where there's no visual injury. You can attack the credibility of the victim, and stuff like that. But it's a very fact-intensive issue. You need to talk to an attorney and make sure that you understand what defenses you have and how you can attack these cases, right? I hope this video has been helpful for you. If you or somebody you care about is facing criminal charges, on the description down below, you'll find my contact information, my booking information. Give me a call and I'll give you a free consultation. We'll talk about your case, see if we're the right fit. I'm here to help. Good luck with your case, and see you in the next video.